3, the application of SDG&E to recover costs related to the 2007 Southern California wildfires. Thank you very much for taking the time to participate in this all-party. I will briefly state, kind of restate our ground rules. We've asked you to sit up in the front, which you have. We have asked you to coordinate your comment time, and my understanding is that the parties have decided to basically divide up their comment time, and so Rachel Peterson will be keeping track of the 2-minute limit for each of the party participants, unless you have individually agreed otherwise, but she'll keep that time, and I will try to help her enforce that time limit. There will be some time on at the end of the agenda for public comment. However, we would like to try to hear as much from parties as possible, and we do have some time limitations for some of the commissioners, so we'll have to see. So I think that's it. So why don't we get started with the opening comments from the utilities, and they have a total of 12 minutes.
Commissioner Randolph, other commissioners, thank you for holding the all-party hearing. We greatly appreciate it. I'm Lee Shavrin, Senior Vice President, Chief Regulatory Officer for San Diego Gas and Electric. I will provide some opening comments. Chris Lyons, our counsel, will speak, and then Edison and PG&E will speak last for us. We're here today because we believe that the proposed decision has significant legal and factual errors resulting in a wrong conclusion in the PD. The PD adopts the expert testimony that the 2007 wildfire event was the result of normal Santa Ana winds for San Diego County. So let's start with one basic fact. I've been with SDG&E almost 40 years. I've resided in San Diego County with my family, and the Santa Ana winds in 2007 for that wildfire in October were not normal. They were hurricane-type winds. I was here, I experienced those winds, I experienced the fire, unlike other experts and witnesses in this proceeding, and my family was evacuated. Commissioners, I'll tell you what, let's ignore all of the expert witness testimony in this proceeding. Let's ignore my personal views on this and experience. And let's talk about a report that was attached to our application called the California Fire Siege of 2007. You all have this in front of you right now. It was attached to our application. It was written by one of your sister agencies of this commission, the CAL FIRE, U.S. Forest Service, and California Office of Emergency Services. Those have been provided to you, and I implore you to read those reports. They're an independent report. Also, commissioners, I'm not sure, but I want to make sure that you're aware that FERC has reached a completely different result from the proposed decision, having already authorized 100% recovery of the 2007 wildfire excess liability costs allocated to their jurisdiction, where they found that we were prudent operators and that the settlements we reached were reasonable as a result of the application of inverse condemnation in the state of California, and in particular the Supreme Court, to this specific case. I would like to now turn that over. I'm sorry, I forgot one other item. Also, I wanted to make sure you were aware that this commission has already approved the SEMA costs related to the 2007 wildfires. That's the restoration cost that was previously approved by this commission. Now I want to turn it over to Chris Lyons to go through the factual and legal errors in the case.
Good afternoon, Commissioners. My name is Chris Lyons. I'm Regulatory Counsel for SDG&E. I'm here to explain to you why you should not adopt the proposed decision in this matter. This is a difficult case, and emotions are certainly high. If you don't know much about the facts of this case, you might assume that the involvement of SDG&E facilities in the ignitions of these fires means that we were somehow unreasonable and imprudent. In fact, SDG&E operated and managed its system reasonably in each instance. But before I address how the PD reached the wrong conclusion in each instance, let me first explain a fundamental legal error that the PD made. SDG&E argued throughout this case, in its application, in its pre-hearing conference statement, in its threshold briefing, in its post-hearing briefing, that recovery of the WEMA costs should be permitted because those costs were incurred as a result of the application by California courts of inverse condemnation to utilities. Indeed, the WEMA costs are settlement costs. We paid settlements to damaged property owners because the Superior Court in San Diego said we could be sued under inverse condemnation. We appealed that to the California Supreme Court, but lost. We settle with damaged property owners because inverse condemnation carries with it the highest standard of liability that there is, strict liability. That means you are automatically liable if your facilities were a cause of the damage, irrespective of fault, and even if only one of several concurrent causes. An inverse plaintiff also gets attorney's fees, which can be significant. Now, the rationale courts have used in applying inverse to public entities is that public entities can spread the costs through taxation. In fact, inverse has been applied to a host of public entities, like municipal water districts and LADWP, even for power line-related fire damage. Later, courts started applying inverse to privately owned, investor-owned utilities in cases involving Edison. And in doing so, they said the same rationale for the application of inverse applies to private entities, that is, cost spreading, that Edison could spread the cost through rates. The FERC took inverse into account when it granted 100% recovery of the federal portion of these costs, and this commission should do the same thing. And I'll also note that FERC found that SDG&E had acted prudently. Now, while we have raised the issue of inverse condemnation repeatedly to this commission, as I said, at every stage of briefing, the commission has been silent at every turn. That is fundamentally wrong. It cannot be the law and policy of this state that costs that are incurred under a strict liability regime where fault is not taken into account, but recovery of those costs depends on a different standard where fault, albeit wrongly applied in this case, is determinative of the outcome. At the very least, we need some explanation as to why the CPUC believes we are different from a public entity that spreads these costs through taxation. Now, while we believe inverse means we get recovery in this case, we also showed that our pre-fire operation and management was reasonable. And as I said earlier, I will explain how the PD reached the wrong conclusion about each fire. Now, with respect to all three fires, where the PD fundamentally goes wrong is it doesn't apply the reasonableness and prudence standard as it's been articulated by this commission, which requires that actions of the utility be judged in light of the facts that were known or reasonably should have been known at the time. Instead, it engages in an analysis that is biased by its hindsight knowledge that the fires occurred. It imposes a perfection standard whereby actions that had nothing to do with the causation of the fires are used to find SDG&E was unreasonable. The commission must rectify these legal errors. Now I'll address each fire. The Witch Fire, CAL FIRE found that the Witch Fire ignited near tie line 637, a 14-mile transmission line in the backcountry of San Diego County, when conductors came into contact with one another, producing sparks that started a fire. There were 4 faults on that day on TL 637, the third of which was tied to the ignition. Now, the PD ignores all of the steps we took on October 21st to investigate the faults and finds we were unreasonable because we didn't de-energize the line sooner. But it does not and cannot point to any real-time information that would have led us to that step, or the testimony of any expert who would have acted differently. It may be apparent in hindsight that the faults on the line were from conductor contact that caused arcing that emitted hot particles, but that was not known or suspected in real time. Faults can result from many things. And on a windy day, faults are not that atypical. It can be a branch or vegetation blowing in the wind. But conductor-to-conductor contact is rarely one of the causes of faults. And in fact, SDG&E had never previously experienced a fire ignition under these circumstances. Ultimately, it would have taken a patrolman to be on scene to see the conductor issue. And while we tried to make that happen, we could not get a patrolman to the location on time. Now, the PD also says we should have sent a protection engineer to determine the fault location, but the evidence shows it would have been impossible to gather the necessary information in time to prevent the fire. The Wajito fire. In the Wajito fire, you had a Cox bundle of facilities strung underneath our distribution circuit. So our circuit was up here, and this Cox bundle is underneath it. The Cox bundle consisted of a fiber optic cable, a messenger wire, and that was all bound together by a lashing wire. CAL FIRE, in its investigation report, and the CPSD, in its investigation report, found that the cause of the fire was the lashing wire breaking, coming undone, that it was dangling 10 to 12 feet from the ground, and blew up into our line, creating sparks and igniting the fire. Now, we raised that argument, and the PD even discusses that argument in the background section on page 27, but then that critical fact is left out entirely of the reasonableness review analysis. It never talks about causation of the fire. Once again, there is no evidence that we knew or should have known about the broken lashing wire, and ultimately, that was out of our control. Now, the PD points instead to a clearance violation regarding the distance between our facilities and the Cox facilities, and says we were unreasonable to allow that clearance violation to exist. But it does not and cannot link any clearance violation to the causation of the fire. Now lastly, the Rice fire. According to CAL FIRE, that fire was caused by downed power lines. In CPSD's investigation, they concluded that the power lines were knocked down by a limb that broke from a sycamore tree.
Your time's up.
No, I'm sorry, it's 2 minutes are left.
Thank you.
Oh, sorry, 2 minutes left.
Sorry about that.
Once again, this limb was not within our control. SDG&E showed that it inspected the tree in July 2007. It also showed that the limb was growing away from the power lines and had a hidden structural defect that caused it to fail in the Santa Ana wind event. We had no knowledge or reason to know that the limb posed a threat. The PD claims that we were unreasonable because we failed to trim the tree prior to October 22nd when the fire ignited. Once again, however, the PD is ignoring causation. Even if SDG&E had done the two things that our inspector recommended, trim the tree to ensure an adequate clearance and remove direct overhang, there is no evidence that either of those steps would have prevented the fire because the limb that fell was neither of those portions of the tree, neither the portion growing toward the conductor or the direct overhang. Let me just conclude and say, in sum, we believe as a matter of law, the PD cannot be adopted. The Commission must take inverse condemnation into account, as FERC did, and it must apply the prudent manager standard correctly, as FERC did, by considering information that was known or should have been known at the time, rather than the hindsight perfection standard that the PD applied. Thank you.
Can we pause their time just for a second? Because I forgot to mention at the outset that there will be time after the parties speak for commissioners to ask questions. So I'm assuming we're going to do questions after the presentations.
So now I'll set this at 2 minutes, so when it rings, that means 2 minutes is up.
We can't hear you.
Are the utilities done?
Yes.
Is the 12 minutes are up? Okay. All right. So can you say that again so I can repeat it so they can hear it?
Now I'll set it at 2 minutes per person, so when this rings, 2 minutes is up, and they're going to see their time.
Okay. Did you guys hear that? So she's going to do a 2-minute. When it goes off, then you go to the next person.
Can I just say something? Edison and PG&E were going to go after us. We ate through the time, so they'll start off in the
May I start?
I think people are still clear with what time remains.
Oh, sorry. So if the interveners would like to go one by one, but they're not keeping time themselves, so I set it for 2 minutes, and when it rings.
So people should get off.
Yes.
Okay.
Great. So you guys might want to have your next
I think you
line up in order.
Order. As I understand it, the second round is for rebuttal. So if you haven't spoken in the first round,
This is an all-party meeting. This is not an oral argument. So each side can allocate their reply comments whichever way they
you
want.
said rebuttal.
No, it actually says reply.
Okay, reply, that's the same thing, reply.
So this is an all-party. It's not an oral
It
argument.
is an oral argument, but that's.
So go ahead and get started.
Thank you. My name is Ed Moldowski. I'm an attorney with the Office of Ratepayer Advocates, and I appreciate the opportunity to speak before all of you today. I don't have much time, so I'll just say inverse condemnation has nothing to do with this case. This is a prudence review in phase one, and one of my colleagues may speak more in depth on that topic. There's also, my colleague pointed to different stages of briefing where inverse condemnation was raised, but not testimony. See, there's a critical question of fact as to whether or not these costs actually are caused by inverse condemnation or not. And that is not something that has been tested by cross-examination. So that is a critical flaw in that argument. As far as the FERC case that was pointed to, that was a different standard. FERC was applying a different standard. It was a serious doubt standard, and it was a lack of challenge. It was a presumption with a lack of challenge. Another issue was different facts. The record that was developed in that case was not nearly as extensive as the record that was developed in this case. For example, in this case we learned a clearance violation was mentioned regarding the Wildfire. Well, that clearance violation had been in the field since August of 2001. That's over 6 years that the Cox facilities and the SDG&E facilities were almost 50% of the clearance that was required. So what we established also in the hearing was that when facilities are closer together, whether the lashing wire was broken before the fire or as a result of the impact, those facilities are more likely to come into contact, more likely to cause a fire. Even if you had a broken lashing wire, when their facilities are closing together, when it would contact it, there's going to be more area that would arc and spark, and thus more of a chance of resulting in a fire. I see that my time is running up. I will also just point to the fact that when we had the, as far as the rice fire is concerned, they said there's no evidence. However, every witness that we saw, that we questioned, saw a direct overhang, but none of the witnesses that were there after the fire saw a direct overhang. So the direct overhang was there before, but it was not there after. Thank you.
Thank you.
We object to this proceeding as a violation of the Bagley-Keene Act because it is a closing argument. You are allowing them to make a closing argument. Their inverse condemnation, the reason that doesn't work is because they chose not to submit what they submitted to FERC to the CPUC. They chose not to call a witness to say we settled because of inverse condemnation. They chose not to call a witness to say we couldn't get enough insurance. The time to spread the potential loss of inverse condemnation is at the time you retain or get your insurance. They had all the money in the world. They could have bought the insurance. They chose not to. They did spread $2 billion of it. They spread $1 billion of it with their insurance policy. They spread another $1 billion, $800 million, through the Cox insurance policy. These judges should be respected by you. We should not be here right now. This is a travesty on top of all the other travesties. Aliso, San Juan, or San Bruno, San Juan Capistrano, all of the other travesties. You're making a mockery out of the CPUC. Don't do it anymore. Don't go down this road. This judge sat there through all the hearings. I was the city attorney of San Diego in 2007. We sued when this fire came. We didn't sue on inverse condemnation. We sued because we learned from Cal Fire that this company started the fire and did not cooperate with the investigation, with the investigators, and did the same thing with safety. This meeting should not be held. This is a closing argument. They're bringing in things that they didn't try. Get that thing confirmed. Use this as an opportunity to turn things around and get yourself back on track. You're supposed to be consumer protection people. You're not. You're not regulating the utilities. The utilities are regulating you.
Good afternoon, I'm Don Kelly from UCAN, and UCAN in this proceedings, our primary focus was focused on the weather event, the Santa Ana wind event that happened at the end of October of 2007. That was, according to Mr. Chavrin, produced extreme weather conditions that in essence, took everything outside of SDG&E's control. In this proceeding, they had SDG&E witnesses. Mr. Geyer, I believe, has actually put forward testimony saying that due to the extreme nature of these winds, the unprecedented nature of these winds, that they are not responsible for acting imprudently. What UCAN's experts and SDG&E's experts conducted a series of tests to try to figure out, could they estimate what the wind speeds were at the sites of the wildfire ignitions at the time that they ignited. And so both of them did modeling, and according to our expert, the model results, the raw data, the model results from SDG&E's expert and UCAN's expert pretty much come up with very, very similar results. The difference, however, is that SDG&E's expert found a way to discard all of the recorded wind and weather data from the remote automated weather stations in San Diego County that were near the ignition locations of the fire. Threw out all of that data and did not bias correct his model. UCAN's expert did in fact use that data to bias correct the model. And here's the difference. Without bias correcting the model, Dr. Paterka, SDG&E's witness,
You
Thank
can
you.
finish your sentence briefly.
SDG&E's witness came up with a figure of 78 to 87 miles an hour at the time of the ignition, and UCAN's expert came up with a figure of 43.1. And the reason why that's important is if you actually take the actual data from all of these weather stations and use it to correct the model that you are producing, you get more accurate results, and that is what the PD found.
Okay, thank you.
Diane Conklin, Musty Grade Road Alliance. It's very nice to see you all back here again. I hope you had a good lunch. SDG&E asked for this hold and got it. You may have noticed PG&E's 3 ex parte meetings announced yesterday after they got limited party status the day before. So what is the real reason you didn't vote on this proposed decision? Qui bono? Who benefits? If this is a matter of CPUC discretion, and if you feel no need to answer the public, then why have a commission? Is this regulation? San Diegans are watching you. How is it possible to take up inverse condemnation with no evidence in the record, and which was out of scope for this phase of the proceeding? If SDG&E wanted to discuss this as a threshold issue, they should have moved to do so early in the process. The fact that they are late is not our problem, and it's not your problem, and the proposed decision should be upheld. The proposed decision reaches the correct conclusion that SDG&E did not meet the prudent manager standard for the witch fire. The commission must move forward and adopt the proposed decision and include any additional evidence that is necessary to support this correct conclusion. Thank you.
Good afternoon. I'm Allison Johnson, speaking on behalf of Protect Our Communities Foundation, as well as speaking with 2 minutes ceded by SD-CAN. POC supports the proposed decision, and there is no reason for the Commission to address inverse condemnation. The WEMA costs were incurred through SDG&E's voluntary settlement, not as the result of an inverse condemnation judgment. After a court allowed litigants to plead inverse condemnation, SDG&E settled, to reduce its litigation costs and avoid admitting liability. SDG&E cannot accept the benefits of this litigation strategy without also facing the consequences. Because SDG&E was not found strictly liable in inverse condemnation, there is no reason for the Commission to even consider allocating recovery under this theory. More importantly, even if a court had found that SDG&E was strictly liable for the wildfire damage, this would not change the Commission's authority and obligation to consider reasonableness. In the cases SDG&E has cited, the courts merely speculated in dicta that the Commission might allow recovery for inverse condemnation. In both Pacific Bell and the unpublished trial court Butte Fire judgment, the court stated that the utilities had provided no evidence that the Commission wouldn't block their recovery in the later review process. The courts did not contemplate the extraordinary type of relief that SDG&E seeks here. Rather, they assumed the costs were incurred due to the risks that are inherent in providing public goods. These courts did not grapple with the Commission's authority to set rates, and there is no precedent for setting aside the Commission's reasonableness standard. Under the case law, inverse condemnation does not make recovery a given. Reasonableness is still a condition precedent. The 2012 WEMA decision concluded exactly that. In that proceeding, SDG&E did not overcome the strong policy concerns that weighed against a wildfire expense balancing account. The Commission concluded that WEMA could remain open only because it would be subject to later reasonableness review. This is the time for that review. Accordingly, the phasing of this proceeding properly reflects the reasonableness standard and the Commission's role as the rate setter. The proceeding was broken up into phases because SDG&E's actions were found unreasonable in phase 1, then there would be no need for a phase 2 to consider the reasonableness of the costs that SDG&E incurred in settling the wildfire litigation. The sole purpose of this phase 1, as scoped by Commissioner Randolph and ALJ McKinney, was to assess the reasonableness of SDG&E's actions. If inverse condemnation were relevant at all, we would argue it's not, it would have been addressed in phase 2. In accordance with this phasing, the evidentiary record does not include testimony regarding inverse condemnation, and the parties were not directed to brief this issue. On this record, it would be improper for the Commission to consider inverse condemnation. Finally, it would also be inappropriate for the Commission to consider inverse condemnation for policy reasons. SDG&E makes much of the cost-spreading justification for inverse condemnation. However, as both the Barham Court and the Butte judgment acknowledge, the purpose of cost spreading is to ensure that individuals do not bear the costs of deliberate operations and maintenance of facilities that benefit the public at large. It's not a mechanism for allowing the public utility to escape liability for its actions. Here, neither the direct wildfire victims nor the public needs to bear SDG&E's costs, so cost spreading is not a compelling justification for recovery. Instead, as the WEMA decision recognized, forcing ratepayers who lost family, friends, health, and property in these wildfires to pay, instead of SDG&E's shareholders, would raise numerous public policy concerns. So in sum, inverse condemnation is nothing more than a distraction. HAWC urges the Commission to adopt the ALJ's proposal and deny SDG&E's application. Thank you.
Thank you. Is that it for the interveners? Okay, so then next are the reply comments from the utilities. And I am particularly interested in a follow-up on this question of, does the fact that the principle of inverse condemnation exists somehow obviate our rate-making responsibilities as a commission? So I really want to hear a response to that because I thought that her presentation made some good points.
Good afternoon, Commissioners. I am Dave Heller, Vice President of Risk Management for Edison. In the interest of time, I'll keep my comments very short. First, I want to make clear that we endorse and agree with SDG&E's position on the PD. Secondly, this is a statewide problem. It's not limited to this particular fire or series of fires, and We, as well as PG&E, are exposed to inverse condemnation, and in fact, we have cases that are working through the system right now related to inverse condemnation. The issue for us is that we are, on the one hand, subject to inverse and do not have the ability to, where there would be a standard of care along the lines of negligence, to prove whether we're negligent or not. And it's this incongruency that needs to be resolved, either by completing the doctrine on the tail end so that there is socialization of cost, or by undoing inverse so that we are subject to a negligence trial and can prove one way or another whether we have met the standard of care that's applicable in the particular case. So with that, I'll defer the rest of the time to SDG&E and answer your specific question.
Good afternoon. My name is Stephen Cairns, and I'm the Vice President of Internal Audit and Chief Risk Officer for PG&E. I'd like to add PG&E's strong support to the comments made by San Diego Gas and Electric. Inverse condemnation imposes liabilities on the utilities without fault. Cost recovery for this liability is a critical issue for all California-based utilities. This PD fails to recognize or adequately deal with this issue. Shifting climate patterns, extending drought, bark beetle infestation has dramatically increased the risk of wildfire. Despite robust mitigations that have adapted to these changes, the risk of wildfire cannot be eliminated. Utilities can purchase insurance. However, increase in this risk and the challenging legal environment in the state has pushed some insurance providers out of this market, while others have substantially increased their premiums. When insurance is unavailable, self-insurance is the only remedy. Thank you for your consideration of PG&E's comments.
Commissioner Randolph, I'd like to address your question about how inverse fits together with Section 451. Now, we believe that inverse condemnation costs, because of what courts have said, that the whole rationale for applying it to privately owned public utilities is that you can spread the cost. We believe that means we should be able to spread the cost, that we should be able to come in here and get approval to spread the cost. However, in this case, we argued in our application that if there are costs that should be subject to a reasonableness review, it's the cost we're seeking to recover. It's the $379 million. What are those costs? Those are settlement costs. And so the reasonableness review, we argued this both in our application and in our pre-hearing conference statement. The real issues in this case should be, did you settle these claims reasonably? Did you offset the amount of money you're seeking with insurance and third-party recoveries reasonably? And we think we did that. Now, we've been accused of not raising this issue. That's nonsense. We raised it in our application. We raised it at every step of the way. And the fact of the matter is that at the scoping memo, the interveners argued that there should be this phase where we look at the reasonableness of our pre-fire conduct. We opposed that and said what you should be looking at is what did we do that gave rise to these costs, which hasn't been done yet, and they want you never to do. And I mean, to say that we haven't raised this is just totally wrong. And then to say that we didn't put on evidence about it. We did put in our application, we submitted testimony of witnesses who talked about the settlements and talked about how those costs came to be. And that was all decided to be phase 2 material because of how the scoping memo phased the case. So we're ready to do phase 2, and we were ready when we filed our application. But it's because of what they argued and how the scoping memo came out that we haven't had a chance to do that. Our ultimate concern is we don't think we should leave this commission at the end of this case and have you had said nothing about inverse condemnation, because we are in this untenable position where we're being whipsawed by the courts having one view that we get to spread the costs, and the commission saying, oh, no, we need to do a reasonableness review, and we're going to impose this perfection standard on you and look at the exact opposite of what the courts look at. Another point about inverse that I want to correct is this notion that we weren't actually found liable of inverse. Now, if you're sued under inverse, if a plaintiff is allowed to make an inverse claim, which they were with respect to the 2007 wildfires, you're automatically liable. You don't have any defenses. So the most reasonable course of action for us to take at that stage, which is what we did, was to settle the cases, because CAL FIRE had found that our facilities were linked to each of these 3 ignitions. So I think they're trying to introduce a distinction without a difference on that one. Now, Mr. Moldovsky made a point about the FERC that I'd like to address. He claimed that the FERC record was different and less developed. Now, the FERC trial staff, which represents the public interest at the FERC, reviewed information from the 2008 and 2009 OIIs into these 3 fires, including the CPSD's allegations of GO95 violations. In general, ORA's theory of the case tracks very closely with the CPSD allegations from the OIIs. FERC trial staff did not oppose our request, and the ALJ specifically allowed recovery of the wildfire costs at FERC, and found that even if there had been a violation of GO95 in a specific instance, that does not constitute imprudence because utilities are not expected to be infallible. We think that's the right discussion. As Mr. Shavrin mentioned, we are also permitted by this commission to recover in our SEMA application for the restoration costs associated with these wildfires. Now, I'd like to correct something Mr. Kelly said on behalf of UCAN. He said, Mr. Geyer or somebody in SDG&E said we're not responsible for acting imprudently because of the winds. We have never said that. That is not a statement we've ever made. Now, on his claims about the modeling of the weather data, let me make an important point here. There is no real-world data that gives wind speeds at the exact time and location of the ignitions of each of these fires. Now, location, where the wind data is being collected from, is particularly important because SDG&E now knows from having deployed 170 weather stations throughout its service territory that wind speeds can vary dramatically over very small distances. The RAWS data that UCAN relied on to validate its modeling were not at locations comparable to the ignition sites and suffered from obstructions that rendered the readings inaccurate and too low. UCAN's witness used RAWS, as I said, to validate, and that is why the PD mistakenly thinks his modeling is better. But the witness acknowledged the obstructions, but he claimed that obstructions only impact sustained wind speeds and not gust measurements. That's nonsense. How could an obstruction of an anemometer, which is recording wind speeds, only affect sustained winds but not gusts? That makes no sense. Now, one more point about inverse I'd like to make. Protect Our Communities suggested that the decisions applying inverse to Edison were merely dicta, and so you shouldn't really take that into account. That's ridiculous. I mean, the fundamental rationale of applying inverse to public entities first and then privately owned utilities second is cost spreading. So telling Edison that you can spread these costs through rates, that's not dicta. That's saying this is why we're applying inverse to you. It's the fundamental reason inverse was applied to Edison. Thank you very much.
Real quickly, Commissioners, in closing, the men and women of SDG&E strive for perfection every single day, but we all know perfection is not possible. And this PD applies the standard of perfection. And if this commission votes out this PD as written, we will have to reevaluate whether we lower the standards for shutting off the power in our back countries. We will have to consider whether we remove trees instead of trimming them. We will have to consider purchasing insurance that is not economical, and we will have to consider undergrounding and put forth applications before this commission that will cost billions of dollars because of the risk that this PD is putting on our company. Thank you.
Okay, so now the interveners will have 10 minutes of reply.
Okay, as to the final point which was made in SDG&E's presentation, SDG&E has an obligation to serve. that can't be tempered by any outcome in any commission proceeding. As far as the point made about the FERC proceeding, SDG&E admits in its brief that the record in the FERC proceeding was different than the record in this case. And that's palpably clear. Yes, there were CAL FIRE reports, but for example, in the Witch Fire, this case went much more in depth as to the time it took to respond, the 6.5 hours it took to respond to the faults on tie line 637. The automatic closer policy, the red flag warnings. There was a much more in-depth investigation of the facts in this case than there was in the FERC case, and it was, also a lack of challenge. As far as there was a reference to the stricken testimony. Yes, SDG&E had included testimony about inverse condemnation in their application, and they struck it. They say it's because it's a phase 2 issue. Well, we never got a chance to cross-examine it. So if you do an analysis of it, there's a fairness issue there as to on this question of fact, because the parties never had a chance to test the assertions that SDG&E was making in cross-examination. As far as perfection, they're saying that we're not perfect, that sort of thing. As far as, for example, in the Wajito case, yes, that was a clearance violation between the southerly conductor and the Cox cable. There was also a clearance violation with the northerly conductor that was detected in the Nolte survey. And if you do the math, from August 2001 all the way to October 22nd, 2007, under California Public Utilities Code section 2108, which counts each offense, each date of an offense as a separate and distinct offense, that's over 2,000 violations. So I see that my time is up, and I thank you.
When the court gets the proceedings, they're going to understand this is closing argument. You can call it whatever you want to call it, but the fact is it is a closing argument. Commissioner Randolph, you're not understanding the issue. This isn't about your rate setting. There was a choice made. These are highly experienced lawyers. They decided what issues, what defenses they wanted to try in front of the judges. They didn't put adverse condemnation into play. They didn't call anyone to testify why they settled it. For them to be permitted to bring that into the proceedings here is ludicrous. It's a joke. You can't do that. They didn't call anyone to say we couldn't get enough insurance. Where you spread it is where you decide to get the insurance. My dear friend Lee Chevron, on cross-examination, admitted they were thoroughly familiar with the Cedar Fire. It was a much bigger fire. Many more homes were destroyed. They knew that, and yet they chose not to buy enough insurance to spread it all. We're not talking about their ability to spread. As I said, they spread $2 billion of it. They just don't get to spread the last $379 million because they didn't get enough insurance. They were found to have acted negligently. The lawyers that were suing them, we could have brought in the lawyers that sued them, and those lawyers we could say, hey, they were suing them for wrongful conduct. They wanted punitive damages. That's why they settled. But we didn't do that. We can't bring that before you now. For you to allow people that were not parties to the proceeding to come into this case now under the guise that this is a all-hands meeting and allow them to enter into the record their arguments that were not subjected to trial, you are impeaching your entire system. Why even have administrative law judges? Why even have proceedings? Why have cross-examinations? Why did we spend all that time doing all that work at the CPUC to do the hearings? So you could come and undo it like this? Again, please use this as a point of disembarkation from the problem pattern of behavior and freshly start again by confirming the fabulous work of your own ALJs. Thank you.
Good afternoon again. Just briefly, Chris, I'll be happy to pull you up the reference of Dave Garrett's testimony. I believe it's on page 5 of this opening. Commissioners, in essence, what the PD does with regards to the weather, the issue that I was focused on, is they believe, the PD concludes that UCAN's estimates are more likely to accurately reflect the weather conditions at the time of the 2007 wildfires. The reason why that's important is because SDG&E has been saying throughout this proceeding that the weather events were unprecedented. And if you make something unprecedented, it's awfully hard to foresee it. So does having an unprecedented weather and wind event in the backcountry of San Diego where wildfires have started absolve them of responsibility because they couldn't have foreseen any potential problems because it was an unprecedented event? What the PD does do is, after examining the evidence from SDG&E's weather experts and UCAN's weather experts, the ALJs had to make a credibility finding. They just had to. We had conflicting testimony. Our estimate was 43.1 miles at the time of the ignition. Theirs was 78 to 87. There had to be a determination. And when the PD concludes that UCAN's estimates are more likely to be, I forgot the exact words, are more likely to be reflect real world conditions. Reflect wind speed conditions at the time of the event. It makes it, as a 43-mile-an-hour event, something that SDG&E would experience every couple of years. I agree, 43 miles an hour is in fact a very strong wind. SDG&E is saying that their wind speeds between 78 and 87 are unprecedented. The PD made the conclusion. I would urge you to follow the PD.
Good afternoon, Commissioners. Joseph Mitchell, Mussey Gray Road Alliance. Regarding the perfection standard, we don't believe a perfection standard was applied in the PD. In addition, there is abundant additional evidence in the record that supports the conclusions of the PD. SDG&E performed meteorological studies in 1981 and again 2006 to 2008 that showed that wind speeds in its service territory could exceed 68 to 120 miles per hour. Yet it still continued to construct, maintain, operate its lines to a 56 mile per hour loading standard. SDG&E also sponsored an academic study in the 90s that showed that conductor-conductor contact could start wildfires, but it never operationalized that information. Also, power line fires were well known in the SDG&E service territory. 1970 Laguna Fire and the Open Fire in 2006, which was sort of a dry run for the Witch Fire in 2007, almost the same place, very similar conditions. All of these taken together meant that SDG&E should have been on much higher alert and applied a much more rigorous standard to its operation and been much more ready to shut off lines when it started to observe faults. So the Commission should move forward and adopt the proposed decision and include any additional evidence that's necessary to support that conclusion.
It is not the Commission's job to resolve confusion created by California's courts, particularly when there is no support to do so in the record. The courts have applied inverse to the IOUs based on speculation about recovery, but the courts are not the rate setters. You are. SDG&E has failed to show any basis for granting its application based on inverse condemnation. The WEMA costs resulted from SDG&E's voluntary settlement, not inverse condemnation liability. There's no reason to deviate from the usual rules for rate setting. As always, the Commission has a responsibility to allow recovery only where just and reasonable. The WEMA costs fall below that standard. The Commission already decided in the WEMA proceeding that it will not entertain an approach to wildfire expenses that eliminates reasonableness review. The WEMA decision recognized that allowing the IOUs to recover all costs that follow from disasters, even if their actions were unreasonable leading up to those disasters, would pose an unreasonable financial and safety risk to ratepayers. The WEMA decision got it right, and now it's time for the Commission to follow through on its order that the WEMA expenses will be subject to reasonableness review. Further, as the interveners have argued throughout this proceeding, allowing recovery here would raise numerous policy issues. Allowing SDG&E to recover the WEMA costs would constitute a windfall, create a moral hazard, and fly in the face of basic fairness. SDG has the opportunity in its general rate cases to seek sufficient funding for reasonable maintenance and for adequate insurance to cover disasters like the wildfires. It also recorded its uninsured costs to the Z-Factor Memorandum account. Allowing them to recover here would not be cost spreading, it would be a windfall. In addition, allowing recovery would ensure that such a windfall recurs on a regular basis. If the utilities have no financial consequences for the disasters resulting from their facilities, this will create a dangerous moral hazard.
Your time's up.
Okay, thank you.
Okay, I think that's the end of the presentations. Sorry, I'm freezing. Do the commissioners have any questions?
Thank you, Commissioner Randolph. I actually wanted to follow up on your question. I'm not sure it quite got answered. And one, just what I heard a little bit, but I guess the question is for both sides here. The conduct before the fire, doesn't that relate to, even if we take the argument that we're reviewing the reasonableness of the settlement, wouldn't the conduct before the fire play into our review?
Commissioner, our position, our application was that the appropriate scope of this proceeding was what's been effectively the phase 2 scope, which is the reasonableness of our post-fire conduct in settling the claims, and that gave rise to the actual costs. Now remember, under inverse condemnation, we were found strictly liable, which means we've never been found negligent or at fault by the court. So we get these costs on our books no matter what. And for that reason, it makes sense to look at, well, did you settle these cases correctly, and so on. So to our position is that's what the reasonableness review here should have been about. Instead, the commission phased it and said, no, before you even look at that, we're going to look at what the court said they weren't going to look at, which is whether our pre-fire conduct was reasonable. Now also bear in mind that our position all along has been, we know you said this was going to be a reasonableness review. You said that in the WEMA decision. And we took that into account and said, okay, we will show you how we were reasonable and prudent in our operation and management of our facilities prior to the fire, and we believe we did that.
Can I just follow up? Because I'm having some trouble with the basic structure of the argument you're making, which as I understand it is because you're strictly liable, or there's a doctrine of strict liability, you can recover from ratepayers even if you didn't act prudently. So therefore, you just said pre-fire conduct is not relevant, it's just what you did post-fire.
Well,
let me ask you, just finish up. One of the fundamental problems I have with that is, doesn't that create precisely the wrong incentives for you to act prudently? If you're going to recover no matter what, because of a strict liability doctrine, why would you act prudently? Where's the incentive? We want you to act prudently and reasonably. That's how we structure our rate recovery. So doesn't that create exactly the wrong incentive for you? The larger the potential liability, if you're potentially liable for billions, then you can act less prudently because you can automatically recover. That seems backwards.
Right. Well, remember, this is a problem that the courts in the first instance have imposed on us. And, if you take SMUD or LADWP, if we were SMUD or LADWP, that's exactly what happened. We would just pass on the cost through taxation or higher rates or however they do it. But we're not. We're SDG&E, and this commission decided it wanted to do a reasonableness review. Now, as far as incentives go, we have every incentive to operate and manage our system as safely as we can. And there are thousands of men and women working for our company every single day that take this decision as an insult, because they're out there inspecting facilities, operating the grid, and having people who aren't experts second-guessing those decisions and saying, you weren't perfect. That can't be the right result here. But as far as incentives go, there's a huge raft of safety regulations that apply to us. And we work day in and day out to comply with all of that. So we're regulated in terms of safety, and we have our own plans. And in fact, the PD found that a lot of our procedures were reasonable. I mean, we have, an extensive vegetation management plan. We inspect over 400,000 trees in our inventory. We have a corrective maintenance program to inspect our distribution facilities. I mean,
So I
we're out
hope you're
here
not
every day.
implying that we don't have the ability or the expertise to review that activity.
I'm not implying that. I'm implying on this record, there's no evidence that we were imprudent.
Right, but you didn't really answer I respect all of what you said, and I'm not trying to, I take as a given that you have thousands of employees who are extremely diligent and dedicated to their work. But doesn't this create a perverse incentive? How does it not create a perverse incentive if you are able to pass on a cost even if you were unreasonable or imprudent?
Well, first of all, we weren't unreasonable.
No, I'm not. That's not the question. I'm asking it as a legal standard. You and Edison and PG joined in your legal argument. You reserve your right to claim that here you were not imprudent. I understand that. I'm just asking you as a higher level matter.
I mean, I can't answer that question in the abstract. I can only answer the question in terms of SDG&E and what has actually happened in reality. And in reality, we've taken these fires and we've said, look, let's do everything we can to make sure this never happens again, regardless of whether we get cost recovery. And we've gone out and done that. And we have spent the last 10 years trying to improve all of our systems in every way possible so that this never happens. We live in this community. We serve this community. We don't ever want to see this again. We really feel people's pain. I mean, a lot of people, including our own employees, were damaged by this. We have no incentive to have wildfires like this. And we have every incentive to operate safely. Now, one thing that gets a little bit lost in the noise of this case is we also said, look, we're willing to make a contribution to this case. And we put in 10% of the total outstanding balance, which is based on a previous commission decision involving hazardous waste. It said we'll contribute that and reduce the costs even further.
Does it?
I hijacked Commissioner Guzman's question, so.
No, I think I have one more question about.
But you wanted to hear from the other side of this, I assume.
Commissioner, you asked just the right question. And here's how that would have worked. So in 2003, we had the Cedar Fire. It was a much, much bigger fire. One of the things that the ALJ found is that put SDG&E on notice because SDG&E filed with the commission and extensively described how horrible and wide-ranging that Cedar Fire was. And so they were on notice, and that's one of the things they said, you're on notice that this could happen. There was almost no wind at the Cedar Fire. So now what happens is that SDG&E has to sit down and say, okay, we're going to buy insurance. We have a right to get the ratepayers' money to spread the potential risk. And that's what we're going to do. Now, they very well could have come in to the proceedings and said, you know what? We weren't able to get all the insurance we wanted. We weren't able to spread it. And they could have put that into play. But they didn't do it. And that's what goes to your point. One more step is that they could have also come in and said, here's all the people that were involved in the settlement, and they're all going to testify that we settled based on inverse condemnation. They didn't do that. So the record that's in front of you right now is on the evidentiary issues and the issues that were framed for trial were what they chose to put in as their defenses. And so now they are trying to introduce something that they didn't try. And the problem with that is that not only does it encourage them to be careful with how they operate their equipment, but it doesn't encourage them to be thoughtful in the way they go about buying insurance. And with you holding them accountable, just for, there's $2 billion plus, you're holding them accountable for a relatively small percentage of it. That will send a market signal to the investor community that will bring pressure on SDG&E and Sempra to be more prudent in the management of the business. And that will be consistent with everything you stand for. It's not going to send any dramatic precedent that all the others are going to have to shudder about. It just means they have to be more careful when they buy insurance. They have to be more careful in the way they operate their equipment.
Do commissioners have any other questions on this or any? And the plaintiffs would have to prove that there was actually a taking of their property, in which the bench trial would have to decide if they were held liable. And it's under a standard of whether their facilities were designed, constructed, operated, and maintained as intended. So that was one of the things that would have been decided in the bench trial that was never decided. Also, SDG&E relies on the FERC decision under New England Power, the interpretation of reasonableness, which includes an element of good faith. And there are, if it does go to a second phase, their settlements were not in good faith. They settled with some, didn't settle with others. Others they had dismissed for procedural reasons. So there was a lot to tell in that second phase, should it go to a second phase. And then also, there's also a question as to the inconsistencies in the CAL FIRE report regarding pilot number 82. CAL FIRE brings it up, but they never do acknowledge about the fire retardant drop that CAL FIRE made on an energized line. And we do suspect that there's some an inference of involvement on CAL FIRE's part regarding that. Thank you. Thank you.
Bill, don't you represent Protect Our Communities? Yeah, go to the microphone. Do you represent Protect Our Communities?
I'm Bill Powers. I'm the board member of the Protect Our Communities Foundation. I'm not an expert witness in the WEMA proceeding.
We dealt with this issue at the public participation hearing. Protect Our Communities was represented, and the fact that you are a board member means that you have already been represented as part of the discussion. So thank you.
Thank you.
I think that's it. Thank you for participating.